Thank you.
SJC-12672, Commonwealth v. Sam C. Wassilie.
Good morning.
1 second, Ms. Kempthorne.
Sorry.
All right, you may commence.
Thank you, Your Honor. May it please the Court, Jean Kempthorne for the Commonwealth. I submit that this is a case that involves a statute where the intent of the legislature was very, very clear. It's a rare case, I think, where it's so clear. It was to strengthen the laws relative to the expectation of privacy, and that's in the enacted statute. To address that is, and to legislatively reverse this court's decision in the Robertson case, which held that the prior version of 272, Section 105B, which is now the first paragraph, did not apply to a camera that is trained on a person's genital area or breast area or similar intimate areas when those are clothed. The legislature effected this intention, I submit, by trying to do or doing three things. One, trying to eliminate a distinction between clothed and unclothed sexual or intimate body parts, and they did that in the definition in 105A, by eliminating distinctions between public and private spaces, or rather one could say extending the reach of the statute to both public and private spaces, and by enhancing the penalties as they pertain to voyeuristic offenses against children.
Well, but isn't there, my understanding is there's paragraph B and section B and then 1, 2, and 3. And 3, that was an addition, wasn't it? And that has a little bit more than what was just described.
Well, what I'm suggesting is that in changing the whole statute, these are the things that were done. There were changes made to A, there were changes made to B. The first paragraph was the pre-existing statute, and then they added the second and third paragraphs. And then there were changes as well made to the dissemination provisions in C.
Now, let me ask you about, you had originally indictments against this defendant under paragraph 1 and 3, is that correct?
Correct.
And the indictments under paragraph 1 were viable, weren't they?
Yes, they were indicted as to the adults.
I understand, but that paragraph could apply to children, couldn't it? Even though it doesn't say children, it doesn't exclude children, and it doesn't limit it to adults.
That's right. I submit that the second and third paragraphs overlap with the first paragraph. They are not.
Is there any lesser included offense issue in here?
Not with respect to the way the charges ended up resulting. In other words, each victim is the subject of a single charge.
Right, but even if that's so, often when you instruct a jury on a lesser included offense, the lesser included offense is not specified in the indictment. So my question is whether section 1 in any way could ever be a lesser included of section 3.
I think it could with respect to a child, because the penalty would be different. It's a felony if it's a child under under the third paragraph.
Okay.
And it is a misdemeanor under the first paragraph.
Ms. Kempthorne?
Yes, sir.
Hi.
Ma'am.
It's okay. No problem.
Judge.
Can you explain what the activity was that was either under or around with regard to this particular case?
Okay, and I think it's in this particular case, like Robertson, you have a stationary phone camera. In Robertson, the defendant was seated a couple of feet away from the victim across a subway aisle, holding it fixed at his waist and simply training it at the prohibited area, the prescribed area, that happened to be clothed. What he actually depicted was the upper leg area. That's what was, in fact. So the under or around clothing in this case, you have children, again, a fixed camera, fixed some number of feet from the toilet seat.
Could you tell us where is the camera, where is the camera in the stall? I'm confused. Is it lower than is it right on the floor? Is it above? Do we know where it is?
I didn't try this case, but my understanding is it was on the floor wrapped in paper towels.
Cell phone camera?
Yes, yes, Your Honor, cell phone camera.
But can we just finish explaining what
Yes.
the over and around is here?
Yes, so the children walk into the field of view of the camera, or the adults. There's, as you know, numerous victims here. And they are initially clothed. So I would submit that when they stand in front of the toilet with the camera there, directed towards there, the area that would be sitting on the toilet, that is Robertson. That is the same thing. The only distinction between that and Robertson is that Robertson takes place in a public place, and this does not.
Well,
This takes place in a private place. I'm sorry.
But isn't the other distinction that the person, the victim, has removed his or her own clothing, so it's not that the camera has gone under or around anything, right?
I am suggesting that, in fact, it has, that in Robertson, which clearly this statute was intended to address, there is no need for a movement or manipulation. Rather, it's that the camera must be focused. And whether it is trying to get at the genital area under the clothing or around it or straight on is immaterial.
Isn't it worse than the MBTA case? Because by definition, when people are using the bathroom, they're going to disrobe.
Exactly.
And it's trained on an area which is going to be under or around their clothing when they go about their business.
It's worse in two respects. One is there's a more intense privacy interest than there is in Robertson. So clearly the statute, the legislature was intending to expand the scope of reasonable expectation of privacy to extend to public places. We don't even have that. We are in a intensely private area with an intense expectation of privacy. We do not have a casual filming or videotaping, videographing. What we have is a highly intentional one, focused precisely on the sexual or intimate parts. As to the under and around, there is nothing that says that the defendant must do the movement. The victims here expected to do this, come in clothed, and they partially undress.
All right, so let's talk about whether that's an element or not.
It would be desirable to have, I think the only case where it really becomes decisive, Your Honor, is if you tried to extend the statute to a person who is totally nude, and there are no clothing in the picture at all.
Well, but
That is not the
But
case.
since the defendant was charged with this, the jury was not instructed on under and around, correct?
Was not because the judge couldn't see what it added and was focused on a different problem in the statute, which I believe is easily obviable with reference to the definition.
Just superfluous descriptive language, or is it actually an important part of the statute?
I think it is not an important part of the statute.
Not important?
I believe it is not. I believe the intention was expansive, not limiting. I think there was no intention to carve out some arcane, limited thing. I think no one could possibly have thought that the statute would not cover
Well, wouldn't
this.
they
But I mean,
have
this
just
was,
thought it
this
would
was a,
have
this was a
included?
peeping, we had a peeping Tom statute. A is a peeping Tom statute. It was designed to address hidden cameras in a locker room, in a dressing room, or in a bathroom. And we had an upskirting case, and the peeping Tom statute simply did not address that particular issue. And the legislature, within days of our doing it, said they're going to add this language to make upskirting, which was not a crime within the peeping Tom provisions, a crime. It's not really rocket science. It's all over it was clear that we said upskirting was not within the peeping Tom provision, and so they made upskirting the crime, which is why it says up and around, because that's what upskirting is. So how can you possibly say that it's not an important part of the statute when the statute was enacted precisely because the peeping Tom provision of A did not address up or around?
Because what they tried to do was to expand this, not put a Band-Aid, not put the Robertson Band-Aid. You wouldn't have drafted it this way. You wouldn't have said sexual or intimate parts are nude, clothed, or partially nude. You wouldn't have needed to do that.
Isn't the real
They tried to expand the whole
issue,
universe.
as in terms of the choice the prosecution made, that you were able to charge specifically with regard to child, which provided with it a sentence increase of 3 years over the 2 years. So it was a 5-year
Prison.
over a 2-year, which seems to me would have influenced the prosecutorial choice. But other than that, there's nothing preventing Section 1 or Paragraph 1 from applying in this case.
That's correct.
Okay,
Section 1 would apply. And in fact, it was applied to the adults.
right.
Right. I think that there are cases to which one applies that the third paragraph does not apply.
Absolutely.
I would agree with that.
Okay.
But I think that if you look at what they were trying to do, it was not put the Robertson Band-Aid. It was to cover the universe of this kind of behavior.
And assuming that's true, they may have that intent and they may have achieved that, but that's not the prosecutorial choices that were made.
But isn't this,
He wants to
no,
interrupt
no,
me.
no,
Let
go
him.
ahead. No, 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 no.
No, we're not
I'm
going to
mindful
let
of
him. We're
this.
going to
I'm
answer
mindful.
Justice Cypher's
This is-
question, and then you'll answer Justice Gaffer's.
I think the consonant with what I believe was the legislative intent, the prosecution applied the felony to the child victims
Right.
to reflect the greater seriousness of that in the minds of the legislature.
Right.
So it was not an end run around the statute or the legislative
No,
intent.
it was just a poor choice
It
because you
was-
don't have elements of upskirting in this.
I believe that we do.
Okay.
Because, in fact, this is not a case where I think it might not apply, which is there's no cle's in the picture. There are clothes in the picture.
So that's
It's
all you need
exactly
is clothes in the
Robertson.
picture?
But aren't you,
Exactly Robertson.
Let Justice Kafka go now. He's having a hard time restraining himself.
no, aren't you trying to prove too much? I mean, if this guy were in the next stall and he stuck his camera underneath the stall up below the person who's partially clothed and partially naked, wouldn't that be upskirting? It may also meet the first one, but that isn't, and that's why I was asking about the location. The camera is below everyone going to the bathroom. It is.
It applies.
It is, what happens is this is a mixture of two different kinds. It's not what the legislator contemplated in one sense, but it's upskirting because we're shooting a picture of someone's private parts from below them.
Absolutely. I've
So
argued that.
we're trying to do too much here by making under go away, and the
I'm
judge.
really not. I'm responding to the defense argument, which says you have to manipulate, you have to move the clothing. That didn't happen in Robertson. So I agree with you, Justice Kafka. We're done. This is an easy
Okay, you
no,
can
case.
agree
it's
with him
not
right
easy.
now, but don't you still have to instruct the jury?
Well, that is, you- I think in this case, it really didn't matter. I do believe absolutely, and I submit, it was never intended to be limiting language. It was never intended to be, oh, if you don't have that, you don't have it. It was really descriptive.
Can I ask
It
a
was
question?
trying to make sure, I'm sorry.
Yeah, no. Just about the indictment. So the indictment says third paragraph with regard to the children?
I actually,
I only ask because,
Yeah.
you know, if you don't need the third paragraph, you can go under the first paragraph, right?
but it was not charged as the first paragraph.
wasn't.
But it was,
I
and it
believe-
was null prost, wasn't it?
Oh, they null prost a whole bunch, but mostly for the reason that they couldn't identify the victims, which I don't understand, but that was the decision.
Well, he was found guilty of the first paragraph.
I'm sorry?
He was found guilty of the first paragraph.
Yes,
and
absolutely. He was
sentenced
found
the
guilty
first
on all the
paragraph.
counts that were tried.
Right. So how can you possibly tell us that it's upskirting without knowing where the camera was placed? Where was the camera placed in the bathroom?
Well, Your Honor, upskirting, I don't think requires that it be.
My question, I mean, it's.
I believe it is on the
matters
floor.
it matters where it was in the bathroom if you're going to say it was clearly upskirting. So where was the camera in the bathroom?
My understanding is it was placed on the floor wrapped in towels.
Where?
Across from the toilet.
So across from the toilet, facing the toilet.
Across from the toilet, facing the
Not
toilet.
under the toilet.
Not under the toilet, across, just like in Robertson.
And how large is the area of the bathroom?
I cannot answer that.
Isn't a picture worth 1,000 words? We have a video of
Yes,
these people.
I have seen the video. It is across.
I mean,
It's a small area. I have watched both
It's a
videos.
stall.
It's
We've
a
got a
stall.
video of someone going to the bathroom.
That's right. We have,
Take a
this is in
genius
the
to
record.
figure out that the camera's on the ground.
Yes. And the defendant places it there. This is nothing accidental. You're capturing the victims in various states of dress and undress. I think this goes directly to the language. I don't think there's any ambiguity
Can I
in
ask
this case.
Can I ask one more fact? I haven't watched the video. I'm not looking forward to it. But are there people with their skirts on, with their underwear down in these videos?
Of course, there's people
Okay, so
relieving
we-
themselves.
So
That's
in
what's
ways
being
we're-
depicted.
So we're gonna, but what do we do with Justice Cypher's question, which is, we don't have any instruction on under. Don't we have
This is
to
true.
reverse that because of that?
This case may require, if you think this is an essential element, and then of course it would have to be remanded because it was not. I think it is harmless in this case because there's just no question.
So even though we're not instructed on that it needs to be under, we can deem it harmless because it's obvious that it's under?
There's,
That's
I
a
believe
question,
so,
not
yes.
rhetorical, yeah. Mhm.
Yes, I believe so.
And cites for that proposition?
I do not have them at hand. I'm happy to supply them. Thank you. Shall I move to the second issue, which is
I'm
the...
afraid your time is up. So,
Okay, thank you.
Ms. Dahlberg?
Nancy Dahlberg for Mr. Wassilie. May it please the court. I'm not often in the role of appellee, so forgive me. I'm going to jump around a little bit here. As to the issue that was just discussed, the Commonwealth conceded in its principal brief that under or around a child's clothing is an essential element of the offense. I know in its second brief it disowned that, but I think that's correct. And the judge stated that there was no evidence of upskirting and that the Commonwealth agrees. That's in his findings.
But that's ridiculous, isn't it? I mean, the camera is underneath. We're gonna all watch this miserable video, but the camera is underneath and pointed up, or we wouldn't be able to see someone's sexual parts, right?
Upskirting, as defined in Robertson, is the practice of secretly photographing underneath a woman's dress or skirt.
Right,
That's what happened.
No, Your Honor, respectfully, what happened is the first paragraph.
What's the difference
Photographing-
between what Justice Kafka said, if this person sat in the stall and put the camera around and filmed it, versus surreptitiously wrapping the camera in paper towels and passively upskirting?
Because if someone sat on the toilet with their skirt and the camera was trained under the skirt, that's upskirting. And the legislature defined the sexual or intimate parts, whether clothed or not, but as upskirting, and I can certainly get into the background of this legislation, where it was absolutely crystal clear that they were dealing with upskirting, which is viewing underneath a skirt or down a blouse.
Can I just ask about the setup? Because I think
Yes,
we're all
of course.
imagining different things. Have you seen the video?
No, I have not seen the video. The Commonwealth has just conceded
no.
that there was no upskirting.
That's
but-
fine.
Yeah.
But my question is because men and women and boys and girls all came through, I assumed it was a a unisex bathroom.
Yes.
So it's one toilet, one sink, one paper towel thing.
Yes, that's my
So it's
understanding.
not a stall, it's a
No.
room, it's a small room, right, with a
Yes,
toilet in it?
yes, yes, yes.
Okay, so the camera is trained, I assume, across from the toilet,
Yes,
where the
I
paper
assume so.
towel thing is.
Yeah.
So we're not talking about going up under anything.
Right.
We're talking about training, it's sitting there, it's not moving, it's stationary,
Yes, Your Honor.
trained on the toilet, and whatever
Yes.
happens at
Yes.
that time.
Yes.
All right.
Okay,
And
can
so
I- can
Judge
I-
Agostini.
Hold it, can I follow up on that?
course.
Because Judge Budd figured out something I didn't.
Oh.
Which is that there's no stall at all here.
Right.
So, again, you haven't seen the video. It's sort of, we're talking in abstractions. It's weird that you haven't seen the video. But for this, do we know whether all we're seeing is below their waist? Or are we seeing a whole person so that it could, because if it's just below the waist, that means it's pointed up, right? Doesn't that matter?
Your Honor, I don't think it matters. The judge found that there was no evidence of upskirting, which has been defined and was clearly defined in Robertson.
The judge is confused about what upskirting is, or he
No,
would
I
have
don't-
instructed on under, or, but go ahead.
If I may. So I will
Are
get
we
to that.
going to
in a
take the definition from Robinson as being the legislative, the discussion or decision about what upskirting means?
I'm sorry, Your Honor, could you say?
I'm sorry. In Robertson, you say that we define what upskirting means.
Yes, it's the
Are we stuck with that? Or is the legislative?
Well, upskirting is generally understood to be photographing under a woman's skirt
But the-
or man's skirt and down a
You have to have a
blouse.
skirt?
The statute's gender neutral, though, right?
So let's say a man is wearing a skirt.
Wearing a
or
skirt.
Well, what's the skirt part? It says under or around a child's clothing.
clothing, so it could be clothing, but what has come up, it has come up, and if you look at the statements of the legislative leaders who passed this legislation, that's what they're talking about, underneath a woman's skirt. But obviously, yes, it could be under.
So if someone
or
films
around.
surreptitiously a 9-year-old boy going to the bathroom, that's not a violation of this?
Not of the third paragraph.
It would
It's
be
a violation of the first
paragraph.
paragraph, as Justice
So
Cipher
that's not the
explained.
intimate parts under or around a child's clothing? That's your definition?
Under or around, accessing a view of the parts that are defined as sexual or intimate in
What
the
if
first.
What if the
in
little boy is
105A.
wearing a long T-shirt that covers himself, as well as shorts, and he pulls his shorts down, and this video is depicting his sexual parts underneath this long T-shirt? Is that not upskirting? Because it doesn't use the word skirt?
Well, I think it depends on if he's, so he's wearing a dress,
No,
essentially.
he's wearing, like, every 9-year-old boy is wearing a football jersey or some long T-shirt that goes below his waist. And he goes to the bathroom and drops his shorts, and this guy has got his camera underneath the thing, and it's showing that. That's not what this statute is addressing?
Well, I would say that child is partially nude under the first paragraph. But what I will get back to here is that the Commonwealth did not challenge the judge's finding that it agreed that there was no evidence of upskirting in this case, and there was no evidence of upskirting in this case, I would submit. The language under or around clearly had to do with reaction to Robertson and criminalizing upskirting, particularly in the circumstances of the Robertson case. And the judge initially didn't know what to make of under or around because it seemed problematic to him. But that was in consideration of the instruction. And in his final ruling, he said, at best, nobody can make sense of this.
So your argument is the prosecution picked the wrong provision to prosecute under. He's guilty, but they picked the wrong provision.
The prosecution was apparently as confused by the statute as many people might be, including the appellate lawyers in this case, which had a difference of opinion between the principal and second brief. Clearly, the then Chief of Appeals, Mr. Pirapan, advised the Assistant District Attorney to get duplicative counts under the indictments because they weren't sure, and I think the inference can clearly be drawn that what they weren't sure about was whether the under or around the child's clothing element could be met.
No, I'm confused because I thought that the assistant district attorney said that they weren't really, they involved different children that were not identified, or different people that weren't identified.
Not
Weren't they
as to
were
certain
they the
things,
same people?
as to the counts 18 to 22, the assistant district attorney explained to the judge that they had sought counts under both first and third paragraphs because the then chief of appeals, Mr. Pirapan, wasn't sure that they could meet the elements of the offense, that they had proof. Did not identify that element, but I think it's a fair inference for us to draw, given the differing opinions as to the meaning of this language, under or around, that that was the problem. In the end, they null-prossed the third paragraph, but no explanation was provided.
They null-prossed the first paragraph.
Excuse me, you're absolutely right.
But they ultimately charged him on the first on the keeping Tom
As to the
provision.
adults.
Right, so,
Yes.
and he received 2.5 year sentences consecutive. He got a total of
did, and-
5 years in the House.
Yes.
So even if you prevail on the upskirting, we still have to, I know you're saying that it should only be one count.
Yes.
But the best you're going to do here is 2.5 years in the House.
Yes.
Okay, so
And I would-
it's not, he doesn't walk away if
Oh,
you-
no,
if-
no,
if
no,
you win.
and truly, and I think there's a little undercurrents somehow that someone once gets away with something, and I would say the Commonwealth has suggested that that is not the case.
Well,
The
but you're-
first paragraph is a
but you're saying-
crime.
But you're saying, no, I mean, you're saying that all the prosecutions against the children were under the wrong statute. Therefore, right? So
Well,
there's
to say
no-
the wrong statute, there was insufficient evidence of guilt under the third paragraph. The Commonwealth chose, even though it apparently had concerns about proof under the language of the third paragraph, to proceed under that. But to Justice Gantz's Chief's point, yes, he's incarcerated. This fellow is incarcerated. He's received 2.5 and 2.5. I do want to get to this argument about the unit of prosecution, because that's actually our appeal, although I certainly appreciate everybody's questions about this statute.
Moving to that.
Oh, yes.
He apparently, I gather he videoed it, and then he came back and videoed it again.
So there was a momentary gap. So the facts suggest that it was started within a momentary period. So it was restarted, so they're created 2 videos, but within the same period of time. And
But it was he who had to restart it.
yes,
So even if you're right that we should be prosecuting the videotaping and not make each individual who was videotaped a separate crime, why is it not at least 2 crimes, since he videotaped it twice?
because, Your Honor, the analysis that's applied in determining the unit of prosecution really talks about an episode. So in this case, it was really one episode. They talk about the same time, the same place, the same criminal impulse. So I really would submit it's not appropriate to break it down by videotape. In this particular case, there happened to have been 2 videotapes created, but it was the same event, the same episode, the same videotaping impulse.
Well, but you can kill 20 people in the same episode and still have 20 victims and 20 counts of homicides. So
Yes,
what's
and
the
this is
difference?
not a violent crime, you know, so the
So it
cases.
has to be violent, and this is not violent.
Well, the cases get distinguished between crimes of violence and therefore victims, number of victims, and crimes against society, which this statute belongs in Chapter 272, and this is secretly conducted, there's no assault element. It clearly fits into that category. And so what gets discussed are episodes, criminal impulse.
So you're saying that Chapter 272 is important, that it was in that
It's
chapter?
important, it's an element. You know, I know in Casbom, although I don't agree with the analysis there, they had a sort of assaultive posing of children and talking about unit of prosecution. But generally speaking, in BOTEV, open and gross lewdness, And in Rollins, they talk about the importance of the placement of a statute in the chapter on crimes against society, essentially, as being an important element. What is not important is the use of the singular, which the Commonwealth has focused on. And so there's nothing here that would move this statute into the column of crimes by which victims become the unit of prosecution.
I don't think the victims would feel that way.
Well, this is the analysis, Your Honor, that's been applied in Botev and
I
in
know.
Donovan. So where there were multiple victims of the person who was guilty of open and gross lewdness, that was one act of open and gross lewdness. Where in Donovan, the defendant placed a phony safe deposit box on the outside of the bank and 7 depositors put money in, it was one count of larceny. Similarly, should be, excuse me, one episode. And it is true that, there's evidence that this was restarted, but it was one episode.
Can I ask about
Yes.
I understand the larceny example. The open and gross lewdness, what were the facts in that?
Someone exposed himself
And there
to
were
two people.
Two people.
But it's, again, one time, one impulse. There's nothing that I have seen that would suggest, pressing a button during the 1 hour period makes it into 2 episodes.
In that case, which case is that?
And, the Botev case, BOTEV, is open and gross lewdness. Donovan is a larceny case. And I would just, could I answer any more questions on that? I wouldn't mind going back to the statute if anybody is interested, or I just would like to say that or wants to talk about it anymore. The Commonwealth's 3-part argument, I think, suggests too much about the legislative intent, and I think that the statute is clear. It uses language under or around that is not used in the first section. It was suggested in Robertson as to address upskirting. Robertson also, they cited two statutes of other jurisdictions that use that language to address upskirting. And it also mentioned a couple of pending bills in the legislature that would have taken a very different tack and not used that language.
Can I ask, is your
Yes.
understanding of the statute meaning only pictures taken over clothing, meaning that you're not actually seeing a naked part? Is that your
No.
I'm trying to understand what your view
No, Your
of-
Honor, I think that it's been defined as accessing a view under a skirt or similar item, or down a blouse or similar item. I suppose it could be from the side. And
That's the only way to make sense of that language? Is that what you're saying?
yes. Yes, Your
But
Honor.
if somebody, Robertson was a subway case. If somebody had put a camera on the bottom of the seat, so it was looking up, is it your view that that would not be upskirting because it was a stationary camera as opposed to a
No,
handheld?
I think that could be, and I will just say that while the Commonwealth may have captured in an artful sentence written by me, I think my brief is very clear on what upskirting is and what the proof is.
So it can be stationary, but it has to be upskirting. It has to be looking up.
Or it could be down a blouse, or...
Okay, but we're not dealing with that here today.
Yes, up the skirt. Yes.
What's the difference between that hypothetical and what happened here?
There's no evidence of upskirting or down blousing here, which the judge
no,
found the Commonwealth agreed.
Right, but we're gonna look at the video. So what's the difference between the hypothetical you just answered to the chief and what happened here?
I don't, unless someone was sitting on the toilet
Right.
with their skirt on.
And you keep
And it
saying, you
accessed-
keep saying skirt, and we know it's gender neutral.
Yes, it's very hard to
So if we have a
do
picture.
with pants.
So if we have a picture of someone, any child, taking their clothes off and sitting on the toilet, and we have a view of their intimate parts, that's not upskirting.
No, it isn't, Your Honor. I
Okay.
would just
How do you
very
get down
briefly
the
add,
blouse?
I'm sorry.
I'm sorry, how do you get down the blouse from around, up or around? down the block? You've been saying, I understand up, but how about down? Where does the camera have to be if it's down?
Would have to be, I suppose if you were sitting on the tee and somebody had a camera like this, I haven't, no.
Where is that in the statute, is what I'm saying? You're
Oh,
down
the around, why they picked around, I
as
can't
opposed
tell
to
you.
down.
Doesn't say down.
Doesn't say down, does it?
No, it says under or around. This is something I haven't had to argue.
Around is another story entirely, isn't it?
It probably is.
Yeah.
I would just say, if for some reason the court finds that the statute's applicable and that, and it's a question of the instruction, I certainly would emphatically suggest that a new trial would be required.
So you don't know whether the camera was directly below the toilet or whether it was across the bathroom
don't.
facing the toilet?
I do not.
Okay,
Thank you.
thank you.